All right, are you Sarah Short there at the jail? No, she's still connecting. They're still connecting. All right, are you Sarah Short there at the jail?
Yes, Your Honor.
All right. Case number 25, CR 36, State of Ohio versus Sarah Short. This is a bond review hearing being conducted by Zoom. Ms. Short was arraigned, I think, on Tuesday on aggravated trafficking, aggravated possession of methamphetamine, and pursuant to statute, since bond was set in the absence of counsel, the court is conducting this review. Her attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office, Assistant Prosecutor King. All right, Mr. Kirk, is there anything you'd like to say regarding the bond?
Thank you, Your Honor. I'm not real familiar with the details of the case yet, but would note Ms. Short is, from all I can understand, is a local person, lives in Hillsborough. This is her first felony that I'm aware of, and no reason to believe she would not appear. She's not currently able to make the bond, so would ask the court to consider either an OR bond or a reduction in the current bond.
All right, Mr. King.
Thank you, Your Honor. Given that these are third-degree felonies, the state feels that the current bond is appropriate. This defendant does not have any prior felony convictions that I'm aware of. I did see back in 2016 where a bench warrant was issued for failing to appear out of Powell District Court in Kentucky, so I would note that. And also, law enforcement did attempt to locate this defendant for several weeks before she finally turned herself in. So based on that, the state would ask that the current bond remain in place.
All right, well, given the fact this is essentially one charge, I'm going to, and there's no previous felony conviction, I do think that a bond is necessary, but I'm going to reduce that bond to $5,000 plus OR and all the other conditions that are in the original entry. So if you do make bond this short, you're under pretrial supervision, and you'll have to report to probation department at 117 East Main Street immediately upon your release. All right, thank you. All right, Stacy. All right, are you Stacy Thacker appearing there from the jail?
Yes, sir.
All right, we have two cases here involving Ms. Thacker. Case number 24 CR 170, case number 25 CR 35, both State of Ohio versus Stacy D. Thacker. This is a plea hearing that was set to request of the parties in both cases. The defendant, as I said, appearing by Zoom from the jail. Her attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office, Assistant Prosecutor King. Ms. Witt, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
We are.
And you're okay with that, Ms. Thacker?
Yes, sir.
All right, now, Ms. Thacker, since you're not seated next to your attorney in the courtroom, if at any point during this hearing you feel that you need to talk with your attorney, you just tell me and I'll put the two of you into a breakout room, and it'll be just the two of you on the screen. No one else will be able to see you or hear you. And during that consultation, the deputy there would step outside of the room and shut the door so your consultation is private, okay?
Okay. All
right, now, in case number 24 CR 170, Ms. Thacker is charged in a 3-count indictment, 1 count of aggravated possession, 1 count of aggravated trafficking and methamphetamine, and 1 forfeiture specification. And in case number 25 CR 35, she's charged with a couple of co-defendants, and she is charged, it looks like, in counts 1 and 2 7, and 9 through 14. And those are aggravated trafficking and aggravated possession of methamphetamine. Now, Ms. Thacker, I've been presented with a couple of plea forms that contain terms of a plea agreement, and I'm going to hold those up to the screen. Make sure that you recognize those. First one is case number 24 CR 170, and says you're going to plead guilty to counts 2, the aggravated trafficking, and count 3, forfeiture. It has your case number and that information on it. I'm going to hold that up to the first page, up to the camera, and ask if you recognize that document.
Yes, sir.
All right, and on page 4, at the end of the page, bottom of the page, the last sentence reads, "I enter this plea voluntarily," and below that appears to be signature Stacy Teeter. I'll hold that up to the camera and ask, is that your signature?
Yes.
All right, now in case number 25 CR 35, that agreement indicates you're going to plead guilty to counts 9 and 13, both aggravated trafficking and methamphetamine. I'll hold the first page of that agreement up to the camera and ask if you recognize it.
Yes, sir.
And on page 4, on this one, at the top of the page, there's one sentence that reads, "I enter this plea voluntarily," and below that, signature Stacy Teeter. And I'll hold that up to the camera and ask, is that your signature?
Yes, sir.
When did you sign these 2 documents, Ms. Teeter?
That was, oh goodness.
All right. I'm sorry?
January 1st.
When was it?
February 21st.
Okay, February 21st. Okay. Now, when you signed these documents, Ms. Thacker, did you understand that they were agreements to plead guilty, meaning there's not going to be a trial, and the next step in each case would be a sentencing?
Yes, sir.
And did you go over these agreements with your attorney and have her answer any questions and explain them to you before you signed it?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
Since it was signed several days ago, today is February 27th, so you've had a little bit of time since you signed that. Have you had any change in heart, or is this still what you want to do?
I would love to ask for a judicial, but yes, I accept.
You wanted to what? Ask for judicial?
Yes, please.
Well, as I read it, these charges, the second-degree felonies, there is no eligibility for judicial release. So, at least as to any second-degree felony, if you are convicted of those, you cannot get judicial release. You could get judicial release after serving any mandatory time, but again, that's not something that's promised. So, do you need to talk with her about that anymore, or did I answer your concern or your question?
Yes, sir, you answered.
Okay. So, you don't need to talk to her?
No.
Okay. So, is it still what you want to do then, is to go forward with these pleas?
Yes, sir.
All right. And you're doing that voluntarily based on the circumstances you find yourself in at this time?
Yes, sir.
All right. Now, on case number 24 CR 170, it says you're going to plead guilty to aggravated trafficking of methamphetamine and count 2, a second-degree felony. And then also count 3, the forfeiture specification. Now, count 2 is a second-degree felony. And under the law, second-degree felony of this nature carries a mandatory prison term between 2 and 8 years as set by the judge. And so whatever that term is that's imposed, there can't be community control, and there cannot be early release. You can get jail time credit against your sentence for participating in certain things, programming in prison, but there cannot be any release earlier than that. And so, your earlier question, that's why I indicated you could not be granted judicial release on that charge. Now, the forfeiture specification is a request to forfeit a 2013 blue Volvo allegedly involved in the offense. So there's no other penalty for that other than the loss of property. Now, with regard to the second-degree felony, I indicated earlier the court imposes if somebody's convicted of this offense, they impose a minimum sentence of between 2 and 8 years. And then under the law, it is possible that the Department of Corrections could extend that beyond the period ordered by the judge. Now, there's a presumption under the law that once you reach that time, that sentence, less any jail time credit and any earned credit from the prison, that you would be released. However, the law does provide that the DRC, Department of Rehabilitation Corrections, could have a hearing, and at that hearing, if they prove to the hearing officers that there are certain determinations that they make regarding your conduct while you were in prison, your rehabilitation, your threat to the society, any restrictive housing, if you were in any restrictive housing while in prison, and what your security classification was during that time. And if there are certain, those determinations are made, the presumption then is overcome, and the department could continue you for an additional period of time beyond that maximum period. And again, that can be done more than once. So they could say, well, we want to extend it 6 months. Then they could say we want to extend it another year or whatever. But the maximum they can do that is 1/2 of the sentence. So under the law, if you got the maximum sentence of 8 years, that it, theoretically, if they made those determinations and went through those procedures, could extend it to up to 12 years. And at that time, then, again, you would get any jail time credit and earned credit while in prison would count against that. And at that time, you would be released. Now, you understand that?
Yes, sir.
All right. Now, under the law, as I said on this one, there's no community control or probation. Now, upon completion of the prison term that's imposed by the judge and any additional time that you would be ordered to be served, if any, by the DRC after they overcame the presumption of your presumptive release date, it is mandatory that you be supervised under post-release control by the adult parole authority for at least 18 months, and there is a maximum of up to 3 years. So you'll be supervised under the terms that the adult parole authority sets by a parole officer. If during that period of time the parole authority finds that you have failed to comply with those conditions, then you could be sanctioned by being returned to prison to serve an additional period of time that they determine is appropriate, up to 9 months for any one violation. And that could happen on more than one occasion, but it would be a cap. There would be a cap or limit of half of whatever the prison term was that was imposed for violations. Now, if you were convicted of a new felony while under post-release control, then in addition to whatever sentence a judge in the new case would impose upon you, the judge could also sentence you for committing the new offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, in the other case, 25 CR 35, it says you're going to plead guilty to count 9, which is aggravated trafficking of methamphetamine under 292503A1. That is a third-degree felony. It carries a possible prison term between 9 and 36 months, a fine of $10,000, mandatory fine of $5,000, and a license suspension of 6 months to 5 years. And then count 13, which is also aggravated trafficking of methamphetamine under 292503A1, but a second-degree felony, the same as in your other case. And the penalties for that, as I indicated earlier, are 2 to 8 years as a minimum mandatory set by the judge, up to an additional 1/2 of whatever the term the court orders, as ordered by the Department of Rehabilitation Corrections under the conditions I mentioned earlier. There's also a fine available for each of those 2 second-degree felonies of $15,000. There is a mandatory fine of $7,500 and a license suspension of 6 months to 5 years. Now, if you are convicted of all these offenses, they can be ordered to be served consecutively. meaning one after the other. So you have 2 second-degree felonies, which are mandatory. So that means that you would be sentenced to a period of 2 years mandatory as a minimum. And if it was consecutive, it could be up to 16 years ordered by the court, 8 years on each. And that sentence would be consecutive or mandatory, and there can be no judicial release or early release of any sort during that period of time. Now, once you serve those sentences, there is a possibility you could be released on the 3rd-degree felony of 9 to 36 months, but it just depends on how that is sentenced. If it's ordered to be served consecutively, then those terms are actually served after the mandatory term. So you would first serve your mandatory term, and whatever those 2 terms were, if that was consecutive, whether it be 2 years concurrent or 8 years consecutive of 16 possible, you would have to serve that before you were eligible. Now, do you understand that?
Yes, sir.
Now, are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, post-release control for a felony in this state?
No, sir.
I'm sorry, I didn't understand.
No, sir.
No, sir. Okay, thank you. All right. Now, I also indicated to you earlier on the other case that the charge in the 25 CR 35, the second-degree felony, the statute also allows that to be extended, as I indicated, by up to 1/2. However, under that law, only one of those charges can be extended. Since they're both second-degree felonies, it wouldn't be if, let's say, I gave you 16 years, they could not have extended that to 24 years. If I gave you 8 years in each count, then they could only extend you on one. So that means the maximum would be 12 years in that case, plus 8 years on the other, for a total of 20 years. And then on top of that could be the 9 to 36 months in the other charge. You understand that?
Yes, sir.
All right. Now, the charge in case number 170 in count 2 alleges that on or about November 12, 2024 in this county, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance, in an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, when you knew or had reasonable cause to believe the methamphetamine was intended for sale or resale by the offender or another person, in violation of 2925.03A2. So that's the aggravated trafficking of methamphetamine, the mandatory prison term, and the other penalties that I described. Count 3 alleges on or about November 12, 2024 in Huntington County, Ohio, you had in possession a 2013 blue Volvo that's subject to the forfeiture due to being an instrumentality in a commission or facilitation of that offense of count 2, as defined under 2941.14.17. And again, that would be the loss of property only would be the sanction penalty for that. Case number 25 CR 35, count 9, reads that on or about November 7, 2024 in Huntington County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, in amount equal to or exceeding bulk amount but less than 5 times bulk amount, violation of section 2925.03A1. So that's the 3rd-degree felony. It's not a mandatory term, but the 9 to 36 months possible incarceration plus the penalties I described, additional penalties I described. And then count 13 alleges that on or about November 8, 2024 in Huntington County, Ohio, you knowingly sold or offered to sell methamphetamine, a Schedule II controlled substance, amount that equals or exceeds 5 times the bulk amount, but less than 50 times the bulk amount, in violation of section 2925.03A1. And so that's also a secondary felony, the same penalty as I described in case number 24 CR 170. All right, now, Ms. Thacker, do you understand what it is you're charged with in each of those counts, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
Have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise in each case, the possible outcomes of a trial in each case with your attorney.
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, sir.
Has anyone threatened you to make you plead guilty in either of these cases?
No, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Right now, on each form, there's sentences that are printed in bold and underlined, and I'll read those as follows. In case number 24-CR170, it reads, the defendant shall enter a plea of guilty to count 2 and count 3. State will dismiss count 1. State and defense jointly recommend 2 years mandatory incarceration consecutive to case number 25-CR35. Defendant agrees to forfeiture outlined in count 3. Defendant agrees to cooperate fully with the task force. In case number 25-CR35, those sentences read, defendant shall enter a plea of guilty to count 9 and count 13. State will dismiss remaining counts. State and defense jointly recommend 24 months incarceration on count 9, consecutive to 2 years mandatory incarceration on count 13, to be served consecutively to the term of incarceration imposed in 24-CR170. Defendant agrees to cooperate fully with the task force, cooperate fully in the prosecution of all co-defendants. Defendant agrees to repay bond money to the task force as follows: $180 joint and several with Michael Carson, $80 joint and several with Sarah Short, and $440 of loans. That'd be a total of $526. Looks like about $700. Now, is that your understanding of the agreement in each case?
Yes, sir.
Now, under the law, Ms. Thacker, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that the court sentenced you to the minimum sentence on the 2 second-degree felonies of 2 years and 24 months on the third-degree felony, which is in the mid-range because the sentence range there is 9 to 36 months, non-mandatory. But none of those recommendations are binding on the court. If you plead guilty, I could, if I thought it was the right thing to do, sentence you to any period of incarceration between 2 and 8 years on those counts that are second-degree felonies for a total of 4 to 16 years, and it would add additional possibility of additional 4 years because of adding 1/2 on one of those sentences, as I explained to you in the earlier statements. Could be 3 years on top of that for the third-degree felony, and I could sentence you to the maximum fine on each case and fine your suspend your driving privileges for 6 months to 5 years in each case. Do you understand all of that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right. Do you have constitutional rights? You must understand before I can accept a guilty plea from you. And the explanation I'm giving you applies to both cases. First of all, you have a right to have counsel. I appointed Ms. Witt to represent you in these 2 cases. And that wasn't simply to work the case out, but to provide any defense to you that might be available to you under the law that you would like her to provide. So if you decide you don't want to plead guilty in either case, then she would continue to represent you and defend you, including a trial if that's what you decided you wanted to do in either or both cases. Do you understand that?
Yes, sir.
All right, now in each of these cases you have a right to have a jury trial in which 12 people be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After 12 jurors are selected in each case, the evidence will be presented. Then the judge would instruct the jury on the law. And then that jury, in each case, would decide whether the state proves your guilt on either or both cases. And the verdicts as to all counts would have to be unanimous, meaning all 12 of the jurors would have to agree. Now, if you didn't want to have a jury trial in either or both cases, you could waive in writing, which means to give up, your right to have a jury trial. And in those cases, you would have what's called a court trial. And that means the judge is the one that hears the evidence instead of a jury. The judge applies the law, and the judge decides whether or not the state proves your guilt of any of those charges in each case. Do you understand that?
Yes, sir.
All right. Now, you have the right to confront the witnesses against you in each of these cases in open court and to cross-examine them through your attorney. What that means is that the witnesses against you would have to come into court in each case and testify in front of you and your attorney and anyone else that's present, because it's a public proceeding. After the prosecutor's done asking questions in those cases, your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, in each of these cases, you have the right to use the power of the court to compel or force witnesses to come in to testify on your behalf to the same as the state. So if you have witnesses you're not certain can come in voluntarily or will come in voluntarily, at your request, the court will issue a court order in either or both cases, as you wish, that will require those people named in the subpoena for that case to come to court to be available to testify on your behalf if you wanted them to. And that's the same way the state's witnesses are forced to come in to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination in both of these cases. What that means is you cannot be compelled to give evidence or to testify in either or both cases at any time. No one can make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in that case. And in fact, no one's even allowed to talk about it if you exercise that right in either or both cases, except in one situation. If there is a jury trial in either or both cases, and you decide not to testify in those cases, the judge does instruct the juries that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, in each of these cases, you're presumed innocent of all charges until proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all at your trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of each offense in each case, and that has to be proven by proof beyond a reasonable doubt, and that's the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, in each of these cases, you entered a plea of not guilty. Not guilty plea denied the allegations in the indictment, denied you committed a crime, and it exercised or invoked all the rights that I've just described for you. Now, if you change your plea from not guilty to guilty on counts 2 and 3 in the 224 CR 170, and counts 9 and 13 in 25 CR 35, that is the opposite of the not guilty plea. The plea to those counts of guilty would waive or give up all of the right, would acknowledge that the allegations in the indictment in those counts are true, that they are an offense, and that you committed that offense. And that plea would waive or give up all of the rights that I've just described for you this morning, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty would waive or give up your right to a jury or court trial. Waive or give up your right to confront the witnesses against you and cross-examine them in open court through your attorney in each case. In each case, would give up your right to use the power of the court to compel or force witnesses to come in and testify on your behalf the same as the state. In each case, it would waive or give up your privilege against self-incrimination because your plea of guilty is your statement that you did it, and that's what's used to find you guilty in each of those cases. And in each of those cases, the plea would waive your right to require the state to prove your guilt, because if you plead guilty to those 2 counts in each case, then they don't have to prove your guilt. It will subject you to being sentenced immediately by the court, which is what's likely since this is a mandatory prison term in each case. And it waives, gives up any right to file an appeal you think you could have had up until this point in the case. Now, if I should sentence you the maximum sentence on any of the counts, or under other limited circumstances, you can file an appeal. Any appeal you want to file would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Thacker?
Yes, sir.
Now, do you have any questions about the charges or the possible penalties in either of the two cases?
No, sir.
You understand them?
Yes.
Have any question about the plea agreement in either case?
No, sir.
You understand it?
Yes.
And again, you understand that the two second-degree felonies require a prison term to be imposed. There's no possibility of judicial release or early release other than jail time credit and earned credit you might earn in prison. You understand that?
Yes, sir.
And you understand that the recommendation on sentencing is not binding on the judge either.
Yes, sir.
Do you have any questions about the constitutional rights I've explained for you?
No, sir.
Do you understand those?
Yes.
Do you have any questions about the plea of guilty or what it would mean if you enter those pleas in these counts, to the two counts in each indictment?
No, sir.
Okay. So you understand the consequences?
Yes, sir.
All right. Now, is there anything you need to speak with Ms. Witt about before we go any further?
No, sir.
Do you have any questions about anything that I've explained to you here today?
Sir.
And you understand everything I've explained to you here today?
Yes, sir.
Then is it your decision to withdraw your not guilty plea, plead guilty to the two counts in each case that's set forth in the two plea agreements that I've just gone over?
Yes, sir.
All right. Then in case number 24 CR 170 in count 2 that alleges that on or about November 12, 2024 in Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution or distribute methamphetamine, a Schedule II controlled substance, an amount equal to or exceed 5 times bulk but less than 50 times bulk, when you knew or had reasonable cause to believe the methamphetamine was intended for sale or resale by the offender or another person, in violation of Section 2925.03A2, which is the charge of aggravated trafficking of methamphetamine, a second-degree felony with a mandatory prison term of a minimum of 2 to 8 years as set by the judge, with a possibility of the DRC extending that under the conditions described in the plea agreement for up to 1/2 of the term imposed, a fine of $15,000, a mandatory fine of $7,500, and possible life suspension of 6 months to 5 years. How do you plead?
Guilty, sir.
As to count 3, which alleges that on or about November 12, 2024, in Highland County, Ohio, you had in possession a 2013 blue Volvo with a serial number is set forth in the indictment, subject to forfeiture due to its instrumentality and the commission of facilitation of the offense is defined in Section 2941.14.17, which is a forfeiture that would result in the loss of that property to the state. How do you plead?
Guilty, sir.
In case number 25 CR 35, count 9, that alleges that on or about November 7, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds bulk amount was less than 5 times bulk amount, violation of Section 2925.03A1, which is a third-degree felony with a possible prison term between 9 and 36 months. Fine of $10,000, a mandatory fine of $5,000, and possible life suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 13, that alleges that on or about November 8, 2024, in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount that equals or exceeds 5 times the bulk amount, but less than 50 times the bulk amount, in violation of Section 2925.03A1. Which is, again, a second-degree felony with the same penalties I described in count 2 and 24 CR 170, mandatory prison term, 2 to 8 years, and the same fines and license suspension. How do you plead?
Guilty, sir.
All right. Court finds that on this day in open court, the defendant was advised of all of her constitutional rights and made a knowing and intelligent and voluntary waiver of the same pursuant to Criminal Rule 11. The plea in each case to each of the counts described in the plea agreement are accepted, and the defendant is found guilty in case number 24-170 of counts 2 and 3, count 1 is dismissed. In case number 25 CR 35, the court finds the defendant was advised of all rights and made a no intelligent voluntary waiver of the same pursuant to criminal 11, and the pleas of guilty to counts 9 and 13 are dismissed, or findings of guilty are entered in each of those counts as charged therein, and all other counts are dismissed as to the defendant. All right. Now, inasmuch as these are mandatory prison terms, in 2 of the counts, 1 in each case, there's no early release possible, and there is a stipulated recommended sentence. The court is going to go ahead and proceed with sentencing. Ben, you want to give me a time? Okay. Now, Mr. King, anything you'd like to say?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation in each case. In the 24 CR 170 case, the forfeiture is to the sheriff's office, and would ask that the clerk be ordered to issue a title for that vehicle to the commissioners. And finally, in the 25 CR 35 case, I would just ask that restitution be ordered as outlined in the agreement. That's all, Your Honor. Thank you.
All right. Ms. Witt, anything you'd like to say?
Yes, Your Honor. We also ask the court to follow the joint recommendation. Ms. Thacker really has no prior criminal history to speak of except a minor misdemeanor. And we also ask the court, due to her impending incarceration, for the fines to be suspended.
All right, Ms. Thacker, anything you would like to say?
I want to apologize. And I accept what you sentenced me to. And this has saved my life. So I'm grateful. That's all.
All right. Well, with regard to case number 24 CR 170, as to count 2, it is ordered that the defendant B, it is hereby sentenced to the Ohio State Reformatory for Women at Marysville, Ohio, to a mandatory term of 2 years of incarceration. Now, as I explained earlier in the plea, under the law, that 2 years will be the presumed time that you should be released, less any good time, any jail time credits that you receive while waiting trial here, and any earned credit you may obtain while serving your sentence as a result of participating in programs at the state penal system. So there is a presumption then that you would be released on that date. However, that presumption may be overcome if at a hearing the department makes specified determinations regarding your conduct while confined, your rehabilitation, and your threat to society, any restrictive housing that was required while you were confined, and your security classification. If those determinations are made, then the presumption is rebutted, and the department may continue to incarcerate you after the expiration of that term and early release date for a time they deem reasonable, which is up to a maximum of half of that term, or 1 year. Now, there could be less than that, but it could be exercised more than once. But again, the maximum extension would be 1 year. Now, upon completion of that prison term, it is mandatory that you be put under post-release control supervision by the Adult Parole Authority in terms they set for a period of 18 months minimum and a maximum of 3 years as they determine. You'll be supervised under those conditions by a parole officer, and if during that period of time they determine that you've not complied, they could return you to prison to make you serve an additional period of up to 9 months for one violation, but there is a cap, a limit of half of your prison term, or in this case 1 year, for all violations. However, if you're convicted of a new felony while under post-release control supervision, then in addition to whatever sentence the judge in the new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. You're also ordered to pay the costs which judgment, grant, and execution is ordered, and if you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, then the court could allow you to do community service in this county and be given credit for each hour you work in an hourly rate set by the court, and each hour you work will reduce your judgment by that amount until paid in full. It's also ordered that you be, or that the vehicle in count 3 be forfeited to the county sheriff and commissioners. It has to be titled to commissioners, so it's ordered that the clerk transfer that title to that vehicle to the county commissioners. And since the defendant is incarcerated, will be incarcerated for a period of time, the court finds that she's not able to pay the mandatory fine, and therefore that is waived, and there will be no license suspension issued. With regard to count number 9 in case number 25 CR 35, it is the order of the court that the defendant be sentenced to a term of 24 months to the reformatory for women in Marysville, Ohio, and as to count 13 to a mandatory term minimum of 2 years. Those sentences are ordered to serve consecutively, meaning one after the other. So the total incarceration in this case would be 48 months or 4 years, and consecutive to the 2 years in case number 24 CR 170. It's also ordered that you pay as restitution set forth in the plea agreement a total of $700 to the Hennepin County Task Force through the victim witness escrow account, and pay any service fee connected to that. The court will also waive the mandatory fine in each of those 2 counts for the reasons previously stated, and will not impose any driving suspension. Now, the court finds that consecutive sentences are appropriate in this case because, first of all, the parties have stipulated to the recommendation of that sentence. Secondly, the defendant has committed these offenses in 2 or more courses of conduct, and the harm that was caused is such because of the amounts and the repeated conduct that one single prison term will not adequately reflect the seriousness of the offenses. And the sentences that are being imposed, being the minimum sentences on the 2 mandatory counts and a mid-range sentence on the 3rd degree felony, are such that they are not disproportionate to the potential sentence, which in this case could have been 19 years. And the court feels that this is also necessary due to the criminal history with these actions, that it's necessary to protect the public from future crime from this defendant. Now, according to the sheriff, you were arrested originally, I believe, on November the 12th. Is that correct, Ms. Packer?
Yes, sir.
All right. Well, that would have been in case number 24 CR 170. And so, let's see, this was printed on February the 5th, and today is February the 27th. So that would be 22 more days. So there'll be 107 days of jail time credit against the 24 CR 170 sentence, and there's no additional time imposed on the, or there's no additional credit for the 25 CR 35 case. Now, upon completion of the sentences in this case, just like in the other case, PRC is mandatory for a period of at least 18 months up to 3 years, with the same consequences I explained earlier. If you're convicted of a violation or found to have violated those conditions, you can be returned for a period of 9 months for one violation, up to maximum of half the term for all violations, and you would have the same PRC supervision as you would in the other case, as I indicated, and the same consequences. All right. Is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right. You're remanded back to custody to be conveyed to the institution, Ms. Thacker. Thank you. All right, this is case number 24 CR 177, State of Ohio versus Rodney McCarty. Are you Rodney McCarty appearing there from the jail?
Yes, sir.
All right, this is a Zoom hearing set for plea at the request of the parties. Mr. McCarty's in custody at the jail. His attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King, on behalf of the state. Defense charged with having a weapon under disability and a forfeiture specification. Mr. McCarty, I've received a plea form which indicates you're going to withdraw your not guilty plea and plead guilty today to both counts. I'm going to put the first page of this agreement up to the camera. Has your name, case number, plea of guilty. I'm going to ask if you recognize that form.
Yes, sir.
All right, and then on page 3, about not quite halfway down the page, the last sentence of that page reads, "I enter this plea voluntarily," and immediately below that appears to be a signature, Rodney McCarty. I'll hold that up to the screen camera and ask, is that your signature?
Yes, sir.
When did you sign this, Mr. McCarty?
Last Friday.
And when you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, sir.
And before you signed this, did you go over it with your attorney and have her answer any questions and explain everything to you?
Yes, sir.
And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
Since there's been a little time passed, have you decided that you made a bad decision, you don't want to go forward with that, or do you still want to do this?
I still want to go forward with this.
All right. Now, the agreement states on page 1 that you are going to plead guilty to both counts. Count 1 being having a weapon under disability in violation of section 2923.13A3, a third-degree felony, and count 2, a forfeiture specification under 2941.14.17. Now, further states you understand that the maximum penalty for count 1 could be a prison term of between 9 and 36 months and a fine of $10,000. And then the maximum, there's no penalty as such for the forfeiture other than you lose the title to the property to the state, which I believe is a gun. Yes, a 9mm Luger 5-point. Now, you understand that?
Yes, sir.
Are you facing any felony charges anywhere else, Mr. McCarty?
Just aggravated possession of a gun.
And,
I'm not operating sentenced.
okay. Well, if at any point in the future you should serve prison terms for both counties, it is possible those sentences could be required to be served one after the other. You understand that?
Yes, sir.
All right. Now, well, also, was this offense while you were under probation in that case? Yes. Okay. So, legally, if you plead guilty here today, it is most likely that that is a conviction is a violation of the terms of community control in Fayette County. Because obey all laws is usually a requirement in every probation case. And so what that means is that regardless of what happens here, if you're convicted here, that could be found to be a violation in Fayette County, and they could decide to go ahead and revoke your community control and sentence you to prison no matter what we do here. Do you understand that?
Yes.
Okay. Now, in the event that you serve a prison term, in this case, once that's completed, it is possible that the Adult Parole Authority would exercise the option to put you under post-release control for a period of up to 2 years. They don't have to. It's up to them. If they do, you'll be supervised by a parole officer under the terms they set, and if during that period of time they find that you are not complying with those conditions, they can return you to prison to make you serve an additional period of up to 9 months for one violation, but there is a cap or limit of half of your prison term for one or more violations. However, if you are convicted of a new felony while under post-release control and sentenced to a prison term, then in addition to whatever term can be imposed for that violation, that judge could also sentence you for committing that felony while under post-release control in this case to an additional period of a year or whatever time is left on post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that? I didn't hear you.
Yes, Your Honor.
Okay. Cut out there.
Sorry.
That's not your fault. That's our correction. All right. Now, Mr. McCarty, I'm not required to sentence you to prison for this offense. I can impose what's called community control or probation. That means instead of going to prison, you'd be put under supervision of a probation officer under a term set by the court for a period of up to 5 years. If during that period of time the probation department thought that you were not complying, they could file a written allegation of that with the court, give you a copy. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to prison for between 9 and 36 months and fine you $10,000. And if your community control was revoked in part or whole because of a new felony conviction like here, and you received a prison term in that case, any prison term that was imposed in this case could be served consecutively to the term imposed in that case. Do you understand that?
Yes, Your Honor.
Right now, the charge in count 1 alleges that on or about November 25 of 2024 in this county, that not having been relieved from a disability as provided under 2923.14 of the revised code, you did knowingly acquire, have, carry, or use a firearm as defined in ORC 2923.11, and at the time you were under indictment for a felony offense involving the illegal possession, use, sale, administration, distribution, or trafficking in a drug of abuse, to wit, aggravated possession of drugs, in violation of ORC 2925.11, on May 17, 2024 in Fayette County Court of Common Pleas, case number CRI 20240082, in violation of section 2923.13A3. So that's the charge of having a weapon while under disability of the third-degree felony with the penalties I described. Count 2 alleges that on or about November 25, 2024 in this county, you had in your possession a 9mm Luger Hi-Point pistol, serial number listed in the indictment, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined under 2941.14.17, which would be a violation of that section that would result in the loss of that weapon to the government. Now, Mr. McCarty, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues of the case, possible defense you might try to raise a trial, and possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, Your Honor. No.
Has anyone threatened you to make you plead guilty here today?
Yes, Your Honor.
Now, the agreement on page 2 has about 2.5 lines that are printed in bold and underlined that read as follows. Defendant shall enter plea of guilty to the indictment. State defense jointly recommend community control and substance abuse treatment. Defendant agrees to the forfeiture outlined in count 2. Is that your understanding of the agreement?
Yes, Your Honor.
Has anyone promised you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, Mr. McCarty, the matter of sentence is up to the judge, not the parties, and so even though there's a recommendation that you get community control, once I've heard all of the information submitted, if I decide that's not the correct sentence, I could sentence you to a term of 36 months in prison, anywhere between 9 and 36 months in prison, and fine you $10,000. You understand that? Now, do you hold any license or certification from any state governmental agency that regulates any trade or occupation in this state?
No, Your Honor.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First, you have a right to counsel, and I appointed Ms. Witt to represent you since you do not have the money to hire your own attorney. Now, her appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you would like her to provide. So, if you decide that you do not want to do this, that you want to defend against this case, she will continue to represent you and defend you, including a trial, if that is what you want. Do you understand that? All right, now under the Constitution, you have a right to have a jury trial in this case, in which 12 people would be chosen from a group of citizens that live in this county that are summoned for jury duty on your trial date. After those 12 persons were selected, the evidence would be presented. They would be instructed on the law, and then that judge would decide, or that jury would decide by unanimous verdict, meaning all 12 would have to agree on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial. And that means that instead of a jury, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that? Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else who may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that would be to try to bring out evidence that may help your side of the case. Do you understand that? Right now, under the Constitution, you have a right to compel witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and have force those witnesses come into court to be available to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that? You can take those two. All right, now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence or to testify in this matter at any time during the case, including trial. So no one can ever make you testify. Prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Thank you. Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden of proof isn't on you to try to prove you're not guilty. The burden of proof is upon the state to prove that you are. In fact, at trial, you don't have to even put on any evidence to defend against the charge. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that? Do you understand that?
Yes, sir.
Okay, I didn't hear it. I've also got a little bit of a cold going on here, so my hearing is being affected a little bit. All right. Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied that you committed any crime, and exercised or invoked all the rights I've just described. If you change your plea today from not guilty to guilty to these two counts, that plea is the opposite of the not guilty plea. The guilty plea admits the allegations in each count, admits that they're a crime, that you committed the crime, and that plea waives, gives up all the rights I've described for you today, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, waive or give up your right to confront witnesses against you in open court and cross-examine through your attorney. Waive or give up your privilege against self-incrimination, because you say you're guilty, that's what you find you guilty. It waives or gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Waives or gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, the waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain limited circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that? And are you a U.S. citizen, Mr. McCarty?
Your Honor.
Do you have any questions about the charge or the possible penalty in either count?
Yes, sir.
Do you understand them?
Yes.
You understand the plea agreement?
Yes.
And again, you understand the recommendation on sentencing is not binding on the judge.
Yes, Your Honor.
You have any questions about the constitutional rights?
Yes, Your Honor.
You understand those? I didn't hear
Yes.
you. Okay.
Yes.
Do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes.
I forgot to say this at the beginning, but if you need to speak with your attorney about anything on this matter, I can go ahead and put you and her into a breakout room where just the two of you are on the screen talking and no one else will be able to see you or hear you. Do you need to do that at all?
No, Your Honor.
All right. All right. And I don't remember if I did this at the beginning, but Ms. Witt, you and your client are both in agreement with this matter being conducted by Zoom rather than in person in the courtroom.
Yes, we are.
All right. And you're all right with that, Mr. McCarty?
Yes, Your Honor.
All right. Do you have any questions about anything I've asked you or talked about here this morning?
No, Your Honor.
Then is it your decision to go forward and plead guilty to the charge pursuant to the terms of this plea agreement?
Yes, Your Honor.
And you're doing that voluntarily?
Yes, Your Honor.
All right. Then as to count one, which alleges that on or about November 25, 2024 in Hiding County, Ohio, that you not having been relieved from disability as provided in Section 2923.14 of the Revised Code did knowingly acquire, have, carry, or use a firearm as defined in ORC 2923.11 of the Ohio Revised Code, and at the time you were under indictment for a felony offense involving illegal possession, use, sale, administration, distribution, or trafficking in a drug of abuse, to wit, aggravated possession of drugs in violation of Ohio Revised Code 2925.11 on May 17, 2024, Fayette County Court of Common Pleas, case number CRI 202400082, in violation of Section 2923.1383 of the Ohio Revised Code, a third-degree felony carrying possible penalty of between 9 and 36 months, and incarceration, a fine of $10,000. How do you plead?
Yep.
Then count two, which alleges on or about November 25, 2024, in Hiding County, Ohio, you had in your possession a 9mm Luger high-point pistol, serial number listed in the indictment, subject to forfeiture due to its instrumentality in the commission or facilitation of the offense as defined in ORC 2941.14.17, a violation of that same section, which will result in the loss of that weapon to the government. How do you plead? Guilty?
Yes,
Okay.
Your Honor.
All right. Thank you. All right. The court finds on this date, open court, defendants advised of all his constitutional rights made no intelligent voluntary way the same pursuant to Criminal 11. Please accept an order filed. Defendants found guilty of both counts. The court will order that a pre-sentence report be prepared. That'll include an assessment for substance use and or mental health issues and treatment recommendations. And the sentencing will be set for April the 2nd at 9 a.m. Officer Benson, you have whoever's doing the PSI contact Fayette County to get their report. I assume they have one on him up there. And are you supposed to do any treatment as a result up there? What was his requirement for treatment by the court up there?
90 days at bars in Circleville.
All right. And you have not started that yet. You came from there down here, right?
Yes, I couldn't take care of this before they could
Right.
come get me to take me to court.
All right. And that's supposed to be residential, right?
Yes, Your Honor.
All right. Well, Officer Benson, if you would tell the PSI officer, and also I'll tell you, Ms. Witt, that if, with view of the recommendation, if there's a bed available for him either there or at, if there's a recommendation for Star or whatever, let me know. And if it's not a recommendation to Star, but a recommendation for residential treatment, I would probably favorably entertain a motion to release him to that program on his OR pending the sentencing. And so if that occurs, Mr. McCarty, if they have a bed available for you and you go up there, it means you have to be there, stay there, and comply with their terms. And if you leave, then your OR bond is terminated and you have to return back to jail. It's not just walk out the door because it's not a custodial facility. They're not going to tackle you or try to restrain you. So if you leave, you have to come back here. And if you don't, then that's a violation of your recognizant OR bond, and could result in a very unfavorable impression on the court. That means you may not get community control. So make sure you comply. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. Mr. King, I just got a message that they're going to shut the water off at 10 for an hour, so anyone in the building that might need to have a convenience break will want to do that before that time.
Thanks for the heads up, Your Honor.
Yeah, so I'll try to get done so that you and I both have that opportunity. Okay. All right. Are you Emma Shoemaker? All right. This is case number 25CR30, State of Ohio versus Emma M. Shoemaker. Ms. Shoemaker is appearing by video from the probation department. This matter was set for a plea hearing at the request of the parties. Her attorney is Danielle Witt, here in her office, appearing for the prosecutor's office, Assistant Prosecutor King, representing the state. And Ms. Witt, are both you and your client in agreement that this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, we are.
And you're all right with that, Ms. Shoemaker?
Yes.
All right. If at any time during this proceeding you feel you need to talk to her, let me know. I'll put the two of you in a breakout room. It'll be just you and her on the screen. No one else will be able to see you or hear you, okay?
Okay.
All right. Now, I have this plea agreement, which indicates that you're going to plead guilty to the charge of trafficking in drugs. I'm going to hold up the first page to the camera and ask if you recognize that plea of guilty form. On page 3, there's a sentence at the end of the paragraph, about halfway down, that reads, "Enter this plea voluntarily." Right below that looks like a signature of Emma Shoemaker. Is that your signature?
Yes.
When did you sign this document?
Last Friday.
All right. When you signed it, did you understand it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case should be a sentencing hearing?
Yes.
Feel you had enough time to fully consider the matter before making that decision?
Yes.
And do you Have you had any change of heart since it's been a few days since you signed it, or do you still want to go through with this?
Go through with it.
Right, so the agreement states that you're going to plead guilty to the charge in the indictment of trafficking into drugs, a fifth-degree felony. But you understand that carries a possible prison term between 6 and 12 months, fine of $2,500, and a license suspension of 6 months to 5 years. You understand that?
Yes.
Are you facing any felony charges in any other jurisdiction?
No, just probation.
Okay, I was going to ask, that's my next question. Are you on probation or community control, parole, or post-release control for a felony?
Yes, in Washington Courthouse.
All right, and that's for a felony, correct? Okay, and were you on probation on that case when this offense was alleged to have been committed?
It happened before I got on probation.
Okay, all right. Well, if at any time in the future you should be required to serve a prison term or a term of incarceration in either county or both counties, those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes.
Now, if you should ever be required to serve this prison term, that's possible in this case if you're convicted in prison, upon completion of that prison term, it is possible that the parole authority would order you to be under post-release control for a period of up to 2 years. They don't have to. It's optional. But if they do, you'll be supervised under terms they set by a parole officer, and if during the period of supervision they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you're convicted of a new felony, then in addition to whatever sentence a judge in the new case could impose for that felony conviction, that judge could also sentence you for committing that offense or under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. Do you understand that?
Yes.
Now, under the law, I'm not required to sentence you to prison for this offense. I can put you on what's called community control or probation, meaning you'll be supervised by a parole or probation officer for a period of up to 9 months on a term set by the court. If during that period of time the probation department felt that you're non-compliant, they would file a written allegation in the court. You would get a copy. There would be a hearing. You'd be entitled to have an attorney. The outcome of that hearing was that you failed to comply. Then at that time, the court could revoke your community control, sentence you to a term of incarceration of 6 to 12 months, fine you $2,500. And if that occurred in part or in whole because of conviction for a new felony and you received a incarceration term for that offense, those 2 terms could be ordered to be served consecutively to one another. Do you understand that?
Yes.
Now, the charge in this case reads that on or about August 21, 2024 in this county, you did knowingly sell or offer to sell Suboxone, a Schedule III controlled substance, in violation of Section 2925.03. So that is the charge with the penalties I've just described. Do you understand what it is you're charged with, what the state said you did, when, where, and how they led you did it?
Yes.
Can you discuss the nature of the charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
I'm sorry, what was it again?
Have you discussed the charge, the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty?
No.
Now, there's about 3.5 lines printed in bold and underlined on page 2 of your plea agreement that reads that defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control and referral to drug court. Defendant agrees to cooperate fully with the task force and agrees to repay bond money to the task force in the amount of $50. Is that your understanding of the agreement?
Yes.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter of sentence is up to the judge, not the parties. And so even though the parties are both recommending community control or probation, the judge is not required to follow that. So once I hear all the information, if I decide that's not the correct sentence, I could impose a sentence of 6 to 12 months incarceration, a fine of $2,500, and a license suspension of 6 months to 5 years. You understand that?
Yes.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation, trade, or profession? Now, you have certain constitutional rights. You must understand before you can accept your plea. First, you have a right to have counsel. Ms. Swift was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you'd like to provide. So if you decide you don't want to do this, that you would rather defend against the charge, she'll continue to represent you and defend you, including a trial if that is what you want. You understand that?
Yes.
Under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. The judge would then instruct the jury on the law, and that jury of 12 would have to decide by unanimous verdict, meaning all 12 would have to agree, on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can have what's called a court or bench trial, which means that it's the judge who hears the evidence instead of a jury, applies the law, and decides whether or not the state proved your guilt. Do you understand that?
Yes.
Now, under the Constitution, you have a right to confront the witnesses against you and cross-examine them in open court through your attorney. What that means is the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else may be present because it's a public proceeding. After the prosecutor's done asking questions, your attorney can then ask questions. That's what's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come to court to testify for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, you request court issues a court order that's called a subpoena, and that forces people that are named in that subpoena to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide you do not want to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about that, with one exception. If you do not testify at a jury trial, the judge instructs that jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including the trial. Wait a minute, I've already said. I just explained that to you, didn't I?
Yes.
Okay. I didn't check it. All right. Now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof is not upon you to try to prove you're not guilty because you've been indicted. In fact, under the law, you don't have to put on any evidence at all. You may, but you're not required to. Whether you do or not, the burden of proof will remain upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Now, you originally entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and to exercise or invoke all the rights I've described for you. You change your plea today from not guilty to guilty, that's the opposite of the guilty plea, not guilty plea. A guilty plea admits the allegation in the indictment, admits it's a crime, that you committed the crime, and that plea waives up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what you plead. Both that exception, your plea of guilty, would waive or give up your right to a jury or court trial. Waive or give up your right to confront witnesses against you and cross-examine them through your attorney. Waive or give up your right to use the power of this court to compel or force witnesses to come to court to testify for you, the same as the state. It would waive or give up your privilege against self-incrimination because if you testify, that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court if that were the decision of the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge or the possible penalty? Do you have any questions about the charge or the possible penalty?
No.
Okay. Do you have any questions about the plea agreement?
No.
You understand each of those?
Yes.
Any questions about the constitutional rights I've explained?
No.
And you understand those?
Yes.
Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yes.
Is there anything you need to speak to your attorney about before we go any further? You need
No.
to speak up. All right. Then is it your decision to go forward and plead guilty to this charge pursuant to the terms of the plea agreement we've gone over?
Yes.
And do you do that voluntarily?
Yes.
All right, then as to the charge which alleges that on or about August 21, 2024 in Huntington County, Ohio, you did knowingly sell or offer to sell Suboxone, a Schedule III controlled substance, and in violation of Section 2925.03A1, the charge of trafficking of drugs, a fifth-degree felony, carrying a possible penalty of 6 to 12 months, fine of $2,500, license suspension 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendants advised of all their constitutional rights made in no intelligent voluntary way of the same pursuant to Criminal 11. Pleas accepted or filed. Defendant is found guilty of count 1. The court refers the matter to the probation department for a pre-sentence report, which includes an assessment for substance use and or mental health issues that may require treatment. The court also refers the case to the drug court docket, so you'll be interviewed by the drug court coordinator to determine if you would like to apply to be on that docket if you receive community control. Sentencing will be set for April the 2nd at 9 a.m. Bond will be continued. Anything further, counsel?
No, Your Honor.
There, Your Honor.
All right, you see the probation officer before you leave, set up your pre-sentence interview. All right?
Okay.
Thank you.
Thank you.